All right. Today's date is December 6th, 2021. In Gray County, Texas, I call cause number 36991 in the interest of Riley Michelle Peden. What says the state?
Your Honor, Teresa DePoister, Assistant Attorney General for the Office of the Attorney General Child Support Division. Your Honor, we do ask the court to take notice of the pleading that is before the court, and that is a motion to change status and also a motion to reduce to judgment and to modify. And attached to that pleading, Your Honor, was a financial statement.
I take judicial notice of the contents of the court's file, specifically the pleadings Ms. DePoister has referred to, the motion to reduce to judgment and modify, or excuse me, the change of status and the attachments thereto. Present by audio and video is Brandy Peden. Are you ready, Ms. Peden?
Yes, ma'am.
Also present by audio and video is Beverly Anderson. Are you ready, Ms. Anderson?
Yes, ma'am.
All right. The court's file reflects that Patrick Zachary was served with notice of these proceedings back on March 29th of 2021. However, he has not made an appearance in today's hearing. It was set for 10:30 and it's now approximately 10:50. So we're proceeding to default Mr. Zachary. Ms. DePoister, you may call your first witness, or do you want to announce the agreement?
Your Honor, I think I'll go over the agreement with my first witness, and if I can call Brandy Peden.
Ms. Peden, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am.
And you are Brandy Michelle Peden?
Yes, ma'am.
And you have a child, Riley Michelle Peden?
I do.
And does Riley reside with you now?
Yes, ma'am.
And previously, though, she had resided with Beverly Anderson. Is that correct?
Yes, ma'am.
Who is Miss Anderson?
She is my mother.
Okay. And you guys are there appearing on the same device today?
Yes, ma'am. She's
Over
right here.
Okay.
Okay. Great. All right. And y'all are in full agreement on that. You believe that this change of status is in the best interest of Riley?
Yes, ma'am.
And previously you had been paid, you'd been ordered to pay child support and medical support for the support of Riley to Beverly. Is that correct?
Yes, ma'am.
And you had fallen a bit behind.
Yes, ma'am.
Okay. And so additionally, Mr. Zachary Patrick had been ordered to pay child support and medical support to Beverly as well. Is that right?
Yes, ma'am.
And I'll ask Beverly about this in a moment, but we delayed the proceedings before because we thought we should take a judgment on Zachary, on Patrick, and and Beverly did go ahead and apply for our services, but our office made a determination not to take judgments for Patrick right now due to his incarceration. Is that correct, that he's incarcerated?
Yes, ma'am.
Okay. Does he spend most of his time incarcerated?
A chunk of it, yes.
Okay. And so he had previously been in TDCJ, but right now he's somewhere else. Is that right?
He's in Gray County jail.
Okay.
He's
Do you know
where?
what the
Gray County.
Okay.
Gray County jail? And do you know what the charges are that he's there for?
Burglary of a habitation.
Okay. Do you know, does he have a blue warrant for any kind of parole revocation?
He should, because he is still on parole for a number of years, but I'm not really sure.
Okay. And yeah, that sounds typical. I'm not aware of it either right now, but so we might anticipate that he'll be incarcerated for at least the next 90 days. Would that be correct?
Yes, I would assume so.
Okay. And so in our new order that we're going to do for you, then we'll have to set child support and medical support at 0 due to his incarceration. Are you okay with that?
Yes, ma'am.
Okay. Now, as to the judgments, then I proposed to you guys, and you guys were in agreement that we just reserve whether a judgment can ever be taken against Patrick for any future order of the court. Is that okay with both of you?
Yes, ma'am. Yes.
Okay. And so the balance that you owed to Beverly for child support, she's releasing that full amount. Is that correct?
Yes.
Okay. And I'll go over it with her too. And so the balance that you owed, I'm taking a judgment as of the last day, or no, as of yesterday, and with that full release. So the child support will be 0 on the arrears, but there is a balance on medical support, and Beverly's wanting to release the portion that she can. So the judgment that will result will be $2,873.72 as of yesterday's date for the medical support arrears. So are you okay with us taking a judgment against you for that balance?
Yes, ma'am.
Okay. And we've talked about a $50 a month payment on that to begin January 1st. Is that okay with you?
Yes, ma'am.
All right. And so then as to the change of status, are you requesting that you be the managing conservator and Patrick be the possessory conservator of Riley?
Yes, I am.
And that you provide the primary residence for Riley?
Yes, ma'am.
Now, do you have some concerns about Patrick in drug abuse?
Yes, he has been more or less had a drug addiction for over 20 years, and he doesn't have much clean time in those. So I really don't want her to have to go with him
Okay.
until he's clean for a while.
Okay. And then the kind of charges he has are burglary and so.
Burglary. His previous charges were all drug related.
All
This
drug.
is the first one that's a burglary one.
Okay. And maybe burglaries to get money for that other issue, huh?
Very possible.
Okay. And so, but you do want Riley to have a relationship with him, is that right?
Oh, of course.
Okay. And you have allowed that in the past, and you would like to allow that in the future. But you're asking the judge today if that could be that visitation would be as agreed by the parties. Is that correct?
Yes. Yeah, I don't mind him coming over here to see her, and he's more than welcome here, but I just want to be able to keep an eye on them.
Okay. And if your order lasts for a while and he gets clean and is not incarcerated, then you would be willing to go ahead and do further visitation. Is that correct?
Yes, ma'am.
Okay. But you want to be able to keep a close eye on that. Is that right?
Yes, ma'am.
And how old is Riley?
She's 11.
And so then at that point, then you'll address that with him whenever that situation happens. Is that right?
Yes, ma'am.
Okay. And does that cover everything that we are asking the court to put in the court order for today?
I believe so.
Oh, I thought of one thing. How is Riley covered by health insurance?
Oh, I'm sorry, Medicaid.
Okay. And so the government will get no payment on the reimbursement for Medicaid as well. All right. Was there anything else that you needed to tell the judge today, or any questions you have?
No, ma'am, I think I'm okay.
Your Honor, nothing further from this witness.
All right. Thank you, Ms. Keaton. You may call your next witness.
Thank you, Your Honor. I call Beverly Anderson.
Ms. Anderson, would you raise your voice? You solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you.
Okay.
All right.
And you're Beverly Anderson, is that correct?
I am.
Okay. And you're Riley Michelle Peden's grandmother?
Yes.
And did Riley reside with you for a period of time?
Yes, she has.
Okay. And then she is residing now with Brandy?
With all of us.
Okay. But you're wanting to go ahead and change the status to be that Brandy is the primary conservator. Is that correct?
Yes, ma'am.
Okay. And you're also wanting to terminate her financial obligations to you for child support, and then to the government, in part to you for medical support. Is that correct?
Yes, ma'am.
And so we would terminate those obligations as of today's date. There was also a court order that ordered Patrick to pay you child support and medical support. Is that correct?
Yes.
Okay. Are you thinking you're ever going to get any of that?
No.
Okay. Well, and because our office never put the order for Patrick on our system, we don't have those figures for you. Do you recall that order said that his child support and medical support would begin upon release from TDCJ?
Yes.
Okay. And so there was never really a follow-up on our system with one of the times he got out. So there's no dollar figure on our system. But I had suggested today that we just reserve any possible judgment for the money he owes you for a future order of the court. Is that okay with you?
Yes.
Okay. And then Brandy owed you money, and there was an arrears as of yesterday's date for child support for $19,416.83, and that all belongs to you. And what are you wanting to do with that money?
I'm gonna release it, but let me tell you, it's gonna be over her head for a long time.
Okay. All right.
Thanks, Mom.
And, go ahead.
Oh no, I'll just tell her thank you.
Okay. And you do understand that once you do a release of the amount that is due to you for on the child support and the medical support, that it is it's gone. You can't recover that. And so it would be a zero judgment today on the child support.
Yes, ma'am, I realize.
Okay. And are you doing that of your own free will?
No, she's got a gun to my head.
Oh, well, we better be clear. Pull that Zoom down so we can see you.
No,
All right.
I'm doing it. She's good.
Okay.
Of my,
All
Lord.
right. And
That's how we live.
Okay. So you are doing it of your own free will,
I am.
and that's what you want to do.
It is.
Okay. And then part of the medical support judgment you can release as well. So the medical support balance as of yesterday's date is $4,803.22. And you can release $1,929.50. Is that what you want to do?
Yes.
Okay. And then the resulting judgment would be payable by Brandy at the $50 a month that we talked about with her. Is that okay with you? Are you in agreement with that agreement?
I am.
Okay, great. And so then, is there anything else that you needed to tell the judge today, or any questions that you have?
No, thank you for putting up with us.
Okay, great. And nothing further of this witness, Your Honor. The state would rest and close.
All right. Based on the testimony and evidence, that I'm granting all of the relief you've requested. I'm granting the judgment against Ms. Peden for medical support only to be paid at $50 per month. And as to Mr. Zachary, I'm going to order visitation as the parties may agree. How old is your daughter, Riley?
She's 11.
Okay. And I'm ordering that due to Mr. Zachary's incarceration. Is there any other relief I need to address specifically?
No, Your Honor, perhaps court costs.
All right. I'm waiving court costs in this matter.
Okay, thank you.
Ms. DePoyster's going to prepare that order, or those orders, there's more than one, for my signature. I expect there'll be more than one order. She might put it all in one order. I'm going to sign off on it, and you should get a copy by email or by regular mail within about 2 weeks. If you don't get one, then you can call the Amarillo AG's office and remind them to send you one.
Okay.
There is a period of 3 business days during which anybody could request a new hearing. If somebody does that, you get a new hearing in front of Judge Vanderpool, and he'd start fresh and make his own decision. But if
Okay.
he does that, this order starts to become final, and you should get a copy.
Okay.
Ms. Peden, you'll want to take your copy when you enroll Riley in school, okay?
Okay.
All right. Thank you, ladies, so much. Good luck to you and to Riley, too.
Thank you.
All right. Bye-bye.
Bye.
Have a Merry Christmas.
Y'all too.
Yes,
Thank you. Thank you, Your Honor.
you bet, Mr. Poyster.
As to the Berry case, Judge, that's number 38133. It's a motion to reduce to judgment. There's no modification.
Yes.
He's caught up on his child support, and there's a very small balance on medical support. So I don't see the point in moving it forward with that, Judge. If it's okay with the court,
Okay.
I plan to non-suit that case.
All right.
And then on the rest, Judge, I guess we'll just reset those and make sure we get notice out for the next setting. I would expect to go ahead and try to set all of them for the next setting.
Okay. You going to go for January? You're going to make it February?
Well, I'd like to do January, but if the court thinks it's better to do February, we can do that.
Well, you go ahead and choose, and I'll just check as the paperwork comes through, okay?
Okay, I think we'll try to do January, Judge.
All right. Well, thank you so much, Mr. Poyster. We'll see you. I'm assuming that, you don't do Collingsworth, do you?
No, I think that's Larry.
Okay, I'll contact